Hey, welcome everyone to the third annual Pennsylvania Farm Show Agricultural Law Symposium. The program will be 2 hours today and then 2 hours on Thursday. So we'll go for 1 hour from now until 2 o'clock and then take a 15-minute break, come back for the second hour, and then repeat that on Thursday. The content for the program, I'll start off in the first hour by reviewing some of the major legal developments at the federal and state level from last year. And then our second hour today will focus on two cases that are pending before the Supreme Court. The WOTUS, so the Waters of the United States, in the phrase in the Clean Water Act, as well as California's proposition dealing with Proposition 12 dealing with the Dormant Commerce Clause. Then moving on to Thursday, our first hour will focus on agricultural antitrust, kind of looking at multi-district litigation in each of the protein sectors. And our second hour then will focus on environmental issues, looking at glyphosate and dicamba, the first part of it, and the second part of it looking at the Chesapeake Bay. I mean, those are two issues that just kind of go on and on and on, but yet they continue to be very, very important issues. So some of the logistics for our program, for those of you that have been a part of our prior programs, we'll pretty much have the same ground rules that this webinar is being recorded. You or anyone else can view this recording on our YouTube channel. The materials are, I believe the materials are currently posted on our events page on the website. And so I think that is just has been posted in the chat. So you can go to the chat box and link to the materials for today. If you do have any questions, please use the Q&A feature, and we will get to those questions during the program. Okay, I want to thank our partners. We work with the Pennsylvania's Department of Agriculture, along with other members in Pennsylvania government in the General Assembly. And we also work as a partner with the National Agricultural Law Center at the University of Arkansas, and they have provided us with funding to put today's program on. So we are very thankful for them for their support of our programs. Okay, so moving into the content of the symposium and looking at some of the major developments from last year. So what I will not, I'll start by telling you what I'm not covering, and that will be the subjects that are discussed in the second hour today, as well as the two hours tomorrow. So I will not be talking about Proposition 12, about the waters of the U.S., about the antitrust, glyphosate, dicamba, or the Chesapeake Bay, but this is what I will be talking about. You can see a pretty lengthy list of topics, which is kind of a sampling of some of the major developments. We'll be talking about some of the same topics that I talked about last year in this program. I think ag gag, cage-free eggs, meat labeling, biotech, ag labor, I think those were all topics last year as well as this year. They continue to be pretty important topics. Also, I'll talk with agritourism and solar. I'll talk about a couple developments that are Pennsylvania specific. Right to farm, there just has been a very recent development in that, actually kind of peeking into 2023. So that's kind of a bonus topic for us as we're talking about developments from the last year. We'll talk about USMCA as it relates to dairy trade, talk about climate and agriculture, and then talk about a couple developments with regard to the organic program. Okay, so to start off with ag gag and ag gag statutes, and just I guess as a kind of background, or for those of you that aren't as familiar with these statutes, this is a term that that refers to state statutes that have been passed that are primarily focused on criminalizing lying on job applications to get access to an agricultural facility, or taking pictures or taking some other kind of recording on an agricultural facility. And the background that or what gave rise to the thought that these were statutes that were necessary or desirable were undercover workers from animal activist groups that would gain access to facilities, and then information that was gathered would be used in a particular way that would cause issues for the ag facility. So these statutes, they generally, I think probably about a dozen states enacted statutes, and they were all a little bit different, but the common thread was they were focusing on information that was provided on job applications or the recording. Now, some of them also did have a requirement that if there was information that was gained, or pictures that were taken, that those pictures had to be turned over to law enforcement. And so that particular requirement was trying to ensure that if there was abuse that was taking place, that the information relating to the abuse of the animals was provided to the police so that it could be dealt with by law enforcement, rather than having it being used as a kind of a PR tool against the agricultural facility. So that's the background of these statutes. There's been extensive litigation in the last years, and generally these statutes have not fared well in litigation, and that trend really continued in 2022. And so we'll first look at Iowa. Iowa, I guess you could say, is the leader in this type of statute. I think they have enacted 4 statutes that kind of fall within this umbrella. And so, what I've indicated here on the slide as Iowa's second statute, this is kind of in a timeline. This is the second statute that they enacted. It was enacted in 2019, and it was focused on that. The job applications. It was focused on prospective employees who used deceit to get access to that production facility, where that person had the intent to cause physical or economic harm. The statute was enjoined in 2019, and then this in 2022. I guess when I say this year or last year, the case was adjudicated on its merits, and summary judgment was granted, and it was permanently enjoined. And the basis for that was that it was unconstitutionally discriminating against that trespasser based on the trespasser's viewpoint of agriculture, because of the intent element in the statute, with the intent to cause harm to that agricultural facility. The court believed or determined that the discrimination was based on someone's viewpoint on agriculture, and so it was thus unconstitutionally discriminatory. This has been appealed, and I believe that appeal is still pending. Okay, the second, again, Iowa. So we're moving up to Iowa statute number 4, which was enacted in 2021, and this deals with, or it criminalized the taking of, using a camera or recording certain information while trespassing in an agricultural production facility. Okay, the same court, Southern District of Iowa, also ruled that was unconstitutional, focusing on the fact that it was burdening free speech without sufficient justification. And so that's really, the First Amendment issues are really how these statutes are generally being evaluated, and this also has been appealed. Okay, now moving to Kansas. Kansas had the very first of these statutes in 1990, and I think North Dakota passed one in 1991, and then there really wasn't a whole lot of activity until probably 15 years later or so, right around, or maybe it was even more than that. It was probably around in the 2000 teens when there really started to be more interest in this type of statute. And so Kansas' statute went along, nobody was challenging it. All the other states start enacting statutes. There gets to be a little bit more interest in this type of statute. Kansas' statute then gets challenged as well. You can see that their statute criminalizes the entry of animal facility with the intent to damage the property, and it involved taking pictures, videos, or using other electronic devices. And this also was ruled unconstitutional, and that was appealed up to the circuit court. The judgment was affirmed, and the state filed a petition for cert with the Supreme Court, and in April of 2022, that petition for certiorari was denied by the U.S. Supreme Court. Okay, and then the final one that we'll talk about today is Texas, and this is a little bit of a twist, because this involves the use of drones to take pictures. So it criminalized operating a unmanned aircraft, a drone, above a CAFO for the purpose of taking pictures. Now, this statute had certain exclusions. So students, professors, insurance companies, or real estate brokers could do that. However, photographers or journalists could not. And so the Photographers Association, or Eighth Photographers Association, filed suit, and the district court in the Western District of Texas ruled that this was unconstitutional, because it was it infringed on the free speech rights of journalists. And part of it was that these exclusions had been granted, but not for journalists. Okay, so that kind of takes us through the Ag-Gag statutes, and I want to highlight issue tracker that we have. And I'm going to, hopefully this will work okay here, where I'm going to our website. So somebody holler at me if you're not seeing the website right now. But this is a research product that we have for a number of topics on our website. You can, along the menu, the drop-down bars on our website, if you go to research by topic, go to issue trackers, then you will come up with a list of various issue trackers that we have. And I'm going to talk, a number of these we're going to talk about today, or the topics we are going to talk about today. But if you go to Ag-Gag statutes, then you can see that we have a listing of litigation as well as the statutes. So here, the Arkansas Ag-Gag statute, you can kind of walk through and see the progression of that lawsuit, as well as get links to a lot of the primary documents. So the complaints, the motion to dismiss, the court opinions, you can get those primary documents. So it's helpful for two purposes. One, just to kind of get a little bit of a timeline as to what's happening, but also you can get those primary documents. So here we have Iowa, and you can see, since Iowa has had different statutes litigated, we have those different statutes, or the litigation of those different statutes. And then just continuing to scroll down at the bottom, here we have the statutes that have been passed. Okay, so I encourage you to get more information, go to this tracker or to other trackers. Okay, next topic, cage-free laws. Arizona kind of joined the club. I think they're the 10th one last year, 10th state that has passed this type of statute. You can see, well, this was this was through a regulation, but the 10th state that has a requirement. And you can see that there's a bit of a phase-in period. So right now through the next 2 years, that there's the requirement is a space requirement that the hens have to be in housing that complies with certain standards, has certain minimum space. But then starting in 2025, it's a cage-free requirement. So a phase-in until 2025. So Arizona, these are the states that Arizona joins. In 2021, there were 2 states, and I think 7 states prior to that. These states, you can see most of them have this requirement that the eggs sold in the state have to be cage-free. Some of them, like Nevada here, just focuses strictly on production. Again, here Rhode Island is just on production. Utah, but some of the states have a production as well as eggs that are sold there. And this is just a kind of a graphic illustration of where are these states. You can see, you know, heavy on the West Coast the last 2 years. The 3 states that have enacted requirements in the last 2 years are Nevada, Utah, and Arizona. So kind of moving from the Pacific Coast inland. And if you look at kind of where are these states in terms of their ranking of egg production, I mean, these aren't the major producers, but there are also some pretty sizable producers. I think Michigan and California, I think, are both in the top 10. Washington, I think, is kind of at the fringe, and Utah as well, I think, are kind of at the fringe of the like in the 10 to 15 range. So some pretty sizable producers that have enacted these requirements. Okay, meat labeling. So meat labeling. So we're talking about kind of manufacturers that are producing, you know, kind of an alternative meat, whether it's plant-based meat or some other product that is that they're looking to have be a substitute for meat in the consumer's mind, and the extent to which they can use the term meat, or how can they advertise that product. And a number of states have enacted statutes to put some restrictions on this. And Kansas joined the club last year with their statute that determines that these products are misbranded if they do not have a disclaimer. And that disclaimer, you know, it has to be, you know, prominent on the labeling. It can include certain words that are going to indicate that there is not meat in that product. Now, the litigation of this type of statute has a little bit more of a mixed record. Louisiana and Arkansas both had statutes that were determined to be unconstitutional last year. You can see Louisiana, you know, their statute addresses meat, beef, pork, poultry, as well as rice. So, you know, not just meat, kind of the same issue with rice. If they're looking to provide some protection to an industry that's important to them, then they don't want or they're concerned about manufacturers selling products kind of trying to cash in or at the expense of their internal rice market. Okay, so the litigation, oops, jumped ahead here. The litigation from Turtle Island filed litigation. The district court in Louisiana ruled that this was unconstitutional on the basis that it didn't directly advance the state's interest in avoiding consumer confusion, and so there was a violation, First Amendment violation of commercial speech. Okay, in Arkansas, you know, pretty much the same result here in Arkansas. I mean, there had previously in 2019 been a preliminary injunction, and now in September of last year, the court ruled on the merits and ruled in favor of the Tofurky company. Okay, with meat labeling, again, you can go to the issue tracker on our website and get lot more information on the specific cases or the statutes. Okay, now moving to biotechnology, and I'm just going to kind of highlight a few different developments related to technology that are, kind of, I guess, across the spectrum on that topic. But first, I wanted to highlight some legal developments related to the American chestnut. And as we look at how biotechnology has developed over the last 25 or 30 years, the products or the GMOs that have really become part of our ag system, our food system, have been corn and soybeans focused on with the BT trait and the Roundup Ready trait. So they've been GMOs that have been focused on that have input traits, meaning they are they're focused on the inputs. They're easier or more desirable to produce. From the consumer standpoint, they don't really add much. Now, I'm going to talk about two products that where there have been developments. First, the American chestnut, which this is still an input trait, but it's designed to resist the blight that has destroyed just about all of the American chestnuts. And I guess when I look at this GMO, it really is pretty similar to the rainbow papaya that was introduced, that really kind of saved the Hawaiian papaya industry a number of years ago. An input trait, but still one that I think is in a different bucket or a different class than the Roundup Ready or BT products. But so this American chestnut has been working its way through the deregulation process. There was another comment period that closed at just about the end of last year, but it looks like we're moving closer to having this product get through all of those regulatory hurdles. The second product that I want to talk about is not focused on an input trait. It's focused on an output trait. The purple tomatoes that Norfolk Plant Sciences is developed, and these tomatoes are genetically modified to have antioxidants, so they're somewhat similar to blueberries, or I think blackberries, that have these heightened levels of antioxidants. And this also is working its way through the regulatory process. And I think this is an interesting product because it is an output trait. So it is providing a trait that at least the developers of this think that the consumers will desire and that they will buy this product because it has characteristics that are different than a quote normal tomato would have. Last year, the Arctic apple is another example of a product that is genetically modified with an output trait. The Arctic apples are genetically modified to have reduced browning, or to minimize the browning when you cut them. So from a food service perspective, if you cut the apples, they're not going to appear to brown as quickly, so they're gonna be more desirable. But this is a product, I mean, that I think maybe consumers may have more interest in, just because of the potential health benefits. So we'll see. I guess it's working through a process, but we'll see if this goes on the market, how consumers respond to that. The other product that I wanted to talk about, genetically modified salmon. This has been an ongoing product for a long time now, and there was an amendment or another environmental assessment that's being undertaken just to look at a particular issue that wasn't addressed or wasn't addressed properly in the prior regulatory process, looking at the impact if there was an escape of these salmon from a particular facility, how that would impact the U.S. So this even though this product did go on the market last year, no, I guess not last, it was 2 years ago, or May of 2021. So it went on the market about a year and a half ago, but we continue to have some ongoing legal developments there. And again, we have a tracker that follows the developments for this particular product. Okay, now continuing on with biotechnology, kind of at a very, very high level view, the coordinated framework for the regulation of biotechnology. This was developed in the 1980s, and this provides the basis for regulation of biotechnology. And I think that probably the biggest takeaway of this is that products of biotechnology will be regulated based upon the product, not the process. So there's not a separate process because they are genetically modified. We're still just looking at the product. And that coordinated framework went unchanged until 2017. It was updated, and now you can see the White House Office of Science, Technology and Policy, as well as EPA, FDA, and USDA published a notice looking for additional any other issues that need to be addressed with regard to that coordinated framework. And this particular notice is basically a result of an executive order that President Biden issued last September, which was you look at this slide, you can see he was basically dealing with all things bio, but as part of this executive order, he directed them to look at ways to improve this process. So they issued that, they being those, the three agencies that have a regulatory role in GMOs, issued that notice last month, soliciting comment on that topic. Okay. And I guess finally with GMOs, GMO labeling or bioengineered food disclosure, as it's really come to be. This topic goes back to, probably almost a decade ago, when there started to be a lot of activity at the state level in considering and then ultimately implementing requirements to label food that contain genetically modified ingredients. In 2016, Vermont had passed a statute. I think it was in 2014. They passed the statute, and it had an effective date of July. I think it was July of 2016. And the coming of that effective date really spurred Congress to enact legislation at the federal level to establish requirements and to preempt state legislation. After the statute was enacted, then there was regulatory activity that took place in order to implement that statute. Now, this topic was always referred to as GMO labeling, with the thought that there would be information put on the label. The statute was, as it was enacted, kind of shifted somewhat that the discussion by not calling it labeling, but calling it disclosure, with the idea that maybe there doesn't have to be a label as long as this information is disclosed in some way. And so the statute provided three ways to implement this disclosure: through text on the label, through a symbol, or through providing some type of link or QR code, some type of electronic way of providing that disclosure. So the USDA's Ag Marketing Service did a study that found that digital option really wasn't going to provide that, wasn't really going to accomplish that purpose. So they came up with the idea that they would use a text. So consumers could text and receive that information. There was litigation on that particular addition, and the court found that the agency didn't have authority to do that, and so they remanded that to USDA's Ag Marketing Service for reevaluation. Okay, now moving on to labor. We're going to talk about a few things at the state level. And when we talk about ag labor, I mean, I think there really are about four major labor requirements where agriculture gets some type of preferential treatment or exceptions from other industries, and those areas being minimum wage, overtime, the ability to unionize, and requirements with regard to child labor. And so I'm going to talk about some changes at state level dealing with overtime and with the ability to organize or unionize, because there definitely is a trend at the state level to kind of give back some of those exceptions that agriculture has. So first, in New York, there at the administrative level in New York, there is going to be, over the next several years, a phasing out of the overtime exception for farm workers. And so, you look in the second bullet point on the PowerPoint, you can see that in 2024, the threshold at which farms are going to have to pay overtime is dropped to 56 hours. And then every 2 years after that, it's going to drop by another 4 hours until, I guess, 9 years from now, in 2032, it's going to be 40 hours. So that overtime exception for ag workers or farm laborers in New York will be completely gone in 2032. In California, I think it was in 2016, California passed the statute that essentially got rid of that exception as well. And that is, again, I'm looking at what happened in 2022 largely in this presentation, but that statute finally became fully implemented there. So you can see that employers that have at least 26 or I guess 26 or more employees now have to pay for 1.5 times. So there no longer is an exception for those ag employers for overtime, and you can see that the requirements change somewhat if you have fewer employees, but that requirement is for 9.5 hour days or 55 hours a week. So there still are some exceptions that are preserved for ag, but they're pretty substantially limited. Okay. Also in California, there were some changes to the ability of agricultural workers to organize. You can see the specific requirements regarding mail-in voting, petitioning, the authorization cards. Those requirements have become a bit more lenient, and there are substantial penalties for employers that are interfering with the employees in this regard. Okay. Also, along with kind of the ability to unionize or organize, Maine, their legislature passed a bill that would have allowed farm workers to organize, and that would apply to farms that had more than 5 employees. The governor vetoed that, and the governor, even though she was generally sympathetic or generally supportive of this, she said that it was subject farmers to something that was too complicated. You can see in the third bullet her quote is that it would require them to hire lawyers just to understand, which I'm sure, most of us on the call would, ask, well, what's the problem if if a law makes you hire lawyers to understand it? But she looked at that as a negative. You can see she was basically saying, okay, Maine doesn't need this. Maine's farms are, she contrasted Maine's family farms with the so-called factory farms and corporate farms that exist elsewhere, and thought that Maine didn't need this particular bill. Okay, also with labor, H-2A, obviously a big topic, an important topic for a lot of farms. There were pretty substantial revisions in October of last year. You can see 172 pages in the Federal Register. Just a little bit of background on this. There was a proposed changes that were that were, I guess, scheduled to be in the Federal Register right at the end of the at the Trump administration. However, during the administration change, there was no action that was taken on those. And so October of last year, the Biden administration published these amended regulations. And you can see some of the topics that are covered within these: health and safety protections, bonding requirements for labor contractors, housing, electronic filing is now mandatory, and some changes with regard to how the prevailing wages are calculated. Okay. Okay, agritourism, just a Pennsylvania specific requirement here with hay rides. So hay rides, the Department of Ag published an order that they do not have to comply with the amusement ride inspection. And so I think this kind of follows along the general theme that we've seen the last several years, that kind of encouraging agritourism, or trying to remove certain barriers to agritourism. And solar. I mean, we've seen a lot of solar development, or interest in solar development in Pennsylvania and elsewhere, and there has been a lot of discussion as to what's the impact of solar development on farmland, and in particular, what's the impact on farmland that is in a that has a conservation easement, that's in a that has some other type of preferred status. And so the Department of Ag just right at the end of last year issued a guidance document. So it's a guidance document, so it doesn't have any regulatory impact, but I think this is an area where there's not a lot out there, and so I think it provides some help. And this is kind of a bonus topic for our 2022 review, because this is really a 2023 issue. But right to repair is a topic that has been there's been a lot of discussion on this topic for the last several years. What is right to repair? Well, it's just the idea that the owner of property has the ability to repair it, or has the ability to, or should have the ability to take it to who they choose to repair it. And if the manufacturer has certain limits, or doesn't provide certain information or tools, then the owner can't do that. And so right to repair removes those restrictions, and potentially puts an affirmative duty on that manufacturer to provide manuals or diagnostic information. And right to repair, this isn't just an ag issue. It's automobiles. The issue has actually been somewhat sorted out with automobiles, but a lot of consumer electronics, iPhones, it hasn't been. And there are a lot of the discussion about right to repair is focused on this consumer electronics, but farm equipment. It's a big issue with farm equipment as well. I guess this is 3 years ago now. Farm Bureau, there was a resolution. Farm Bureau, they have a process that states can submit items to have all the national delegates vote on, and the delegates expressed support for right to repair, indicated that the preferred method to implement this would be through some type of agreement with equipment manufacturers, but legislation would be supported if an agreement couldn't be reached. Industry, I guess this predates that a little bit, because we're talking about these principles in 2018, but industry has undertaken some efforts to respond to the consumer demands. And I guess you could look at this a couple different ways, either that they're trying to accommodate customers, or maybe a little more cynically, they're trying to take actions that are going to continue to give them control over the issue, rather than having losing control if there is state legislation that's enacted on this topic. Okay, so coming up to the present date, and this is just 2 days ago. So this is on Sunday. There was an MOU that was signed between the American Farm Bureau Federation and Deere and Company. And the gist of this MOU, I have 2 bullet points that I think kind of summarize. The MOU is several pages long, but I think the gist of it is that, on one hand, Deere and Company signed this. So the manufacturer is Deere and Company, that they're going to make sure that the farmer, as well as an independent technician that's assisting the farmer, is going to have access to information so that the equipment can be repaired. On the other hand, what's kind of Farm Bureau giving to Deere and Company, and it's that Farm Bureau agrees that they are going to refrain. They're going to encourage their state organizations to refrain from supporting any legislation that imposes obligations beyond those commitments. So that's kind of the trade-off, that Deere and Company is going to provide the information. Farm Bureau is not going to lobby for anything more than that. One other issue with right to farm, also kind of over the holiday break, New York State passed a right to farm law, or excuse me, a right to repair law, and it was signed by the governor, but it doesn't deal with agricultural equipment. It deals with consumer electronics. But you may, now that we're kind of in the new year, you may hear some publicity about New York's law, and just I think it's important to know it doesn't apply to agricultural equipment. Okay, USMCA. USMCA is kind of the successor to NAFTA. This is the international trade agreement between the US, Mexico, and Canada. And the first trade dispute under USMCA dealt with dairy, and specifically with Canada's allocation of the dairy tariff rate quotas. And essentially, Canada, in the way that they are prioritizing or allocating the dairy, the products from the U.S. that can be imported into Canada, they're giving priority to processors rather than direct sellers. And so the U.S. is taking issue with that, saying that is not in compliance with Canada's obligation under USMCA. And so there was a dispute settlement panel that was established. And right at about a year ago at this time, the panel came back finding that the U.S. prevailed on this particular issue, that Canada was violating it with regard to this TRQ allocation. So Canada then made some changes to their requirement. I'm not going to get into the specifics of it, but they made some changes to their requirement, and those changes there was not a good response from the U.S. dairy community. Didn't think much of the changes. Didn't think that they had brought Canada in line with their obligations under the treaty. Again, Canada thought that they had made those made changes. Here's a statement from May from the U.S. Trade Representative, which indicates that the U.S. did not believe that Canada had brought their TRQ allotments into their obligations as it moved forward. And so I guess at this point, what can the U.S. do? Well, if Canada doesn't bring it doesn't bring their requirements in line with the obligations, then the U.S. could retaliate in some way. That hasn't happened to this point. However, on December 20th of last year, the U.S. is kind of widening the field and saying, well, there are some other things with Canada's requirement that also violate the USMCA, and so now the not just providing the priority to the processors rather than the sellers, but the use of a market share as a way of establishing the allocations. The U.S. is now taking issue with that and is asking that there be the consultations, that process is being initiated on that particular issue as well. Now, moving outside of USMCA, but still in kind of the arena of international trade with regard to dairy, I mean, you can see New Zealand also has an issue with this dairy tariff rate quota that Canada has as well, and is claiming that it is violating another trade agreement that Canada has, a trade agreement that Canada and New Zealand are both parties to. So this TRQ allocation from Canada, problematic from the US's perspective, as well as New Zealand in a different trade agreement. Okay, now sticking with New Zealand, because I'm sure you all are very interested in what's going on in New Zealand. Last October, they announced consultations for an agricultural or a proposed agricultural emissions pricing scheme. And I thought this was interesting because, when you think of environmental regulation, the kind of the two classical ways that you can address an environmental issue is through, either through the carrot or through the stick. And, this definitely looks to be a stick approach at addressing agricultural emissions. And if you look at how this issue has been addressed in the U.S., kind of going back probably a decade, even though the discussions in the U.S. were often focused on reporting or monitoring, not assessing any type of assessment. But I think there was concern in the ag community that's what was coming, and there was a lot of resistance to any type of program related to emissions. I think because there was a concern that the stick was coming, and so it looks like that is the approach that New Zealand is taking here, and that's the approach that's being taken in the Netherlands. Now, I guess this slide's a little bit misleading because it's labeled government nitrogen policy, and their government nitrogen policy is not to set fires along the road, but that has been the response to their policy. I mean, their policy has been to impose requirements to minimize the amount of emissions that farms are producing, and so the concern is that is going to reduce, that farms are going to have to reduce their size or their production, and I think farms are feeling like they are being forced to kind of bear the obligation or the responsibility for the society in reducing these emissions. And in the U.S., this topic, the climate topics, I think you go back a few years and it seems like there has been a shift from the stick to the carrot. And so you look at last year, USDA in February announced that they were going to provide up to $1 billion to support this climate smart partnership, where they were going to work, USDA was going to work with other entities or provide funding to other entities to work with producers in installing climate friendly practices in agriculture. And so, you can see that that these practices, we kind of have somewhat of a list: cover crops, low till, no till, nutrient manure management. I mean, these are all practices that should sound familiar, because these are practices that have been part of our conservation programs that we have had. But now these requirements are kind of being, I don't want to say rolled into, but these are practices that are now forming the basis or forming an integral part of these climate smart programs. So in February, USDA announced that they were going to provide up to $1 billion in funding. They actually provided, in September, they announced that they had provided $2.8 billion. So a lot more than they were originally going to, and they said it was based on the strength of the proposals that they had received. Okay, and so let me just check my time. So okay, 1:54. So a few minutes. Just a couple items related to organic. I mean, along the kind of the lines of USDA providing funding to support certain programs. There is funding for organic transition. I know we've seen that in the past. We've seen that in the past at the state level in Pennsylvania, but there is a program here to deal with farmers transitioning for that, the time period that it takes to transition. Now there's some funding that makes it easier to encourage farmers, and there have been some or a change to the requirements for organic dairy, again focused on that transition. And so there is a one-time, generally the cattle have to be or raised under organic management from the last third of gestation, and this exception allows one time to do this transition, so that somewhat to kind of synchronize the animals in making that transition. So we have, I guess, 5 minutes. I'm not sure if I can't see if we got any questions or not, but I'm happy to take any questions that we have.
Yeah, Ross, this is Brooke. We do not have any questions.
Okay.
In the Q&A. I had one thing that I wanted to add, which goes back a few slides. I figured we could just add a couple little side issues. On the H2A regulations. Yep. Let's see what number that is. On those, there we go. Okay, I just happened to be doing, you can go to the next screen.
This one?
Yes, that's good. I've been doing a couple of webinars on this recently and discovered, which I had missed it initially, that in early November, I think it was, the National Association of Agricultural Employers, which some people might be aware of, they are the leading ag employer group. They actually filed suit to stop these regulations, saying that the process whereby the Biden administration had withdrawn the Trump version of these regulations at the last minute after they were delivered to the Federal Register's office, but they had not been published yet. And then inauguration happened, and on the very day of inauguration, the Biden administration pulled those regulations back. The theory of the lawsuit is that essentially the publication in the Federal Register wasn't required for those to, in fact, be effective and have been completed according to the Administrative Procedures Act. So they're saying the theory in the lawsuit is that to change those in any way at the point that they were on the day of the Biden inauguration, there would have had to have been additional comment, an opportunity for public comment, and an entire another step of publishing, a public solicitation of comment on any changes. So, and that actually has some attractive, parts to it. So that lawsuit, however, has not been successful in getting a preliminary injunction. That was denied. And it'll be, I think this is coming up in our Ag Law Weekly review, maybe next week, I forget, or maybe it was in this week. But there is a motion for a permanent, or for a permanent injunction still pending. And so we will see whether that, results in any stoppage of those H2A regulations. Just in general, they were, of course, more friendly to employers, as one would expect, having been drafted by the Trump administration. In other words, the previous version. This version is a bit less friendly or less supported by employers. Hence the Association of Ag Employers suing to stop them. So that's a little bit still in play. And so we still wanted to mention that. And one more thing, Ross, or is there something in the Q&A? Let's see.
No, I think we're good. I think we're good.
Okay. Okay. One more thing was on the Ross was moving real fast through the issue of the hay rides. And so the issue, and this, if you didn't follow this, it was a little bit odd, because what was actually waived was the requirement with your registration paperwork to the Bureau, or to the Division of Amusement Ride Safety, a engineer's certification with regard to the hayride in this case, and its design, et cetera, et cetera. And so the paperwork to register the hayride is easier. Now, this was big news to most people, that there even needed to be a registration of a hayride. So that was sort of shocking to so many in the industry, because that really was not something that had been in any way, shape, or form enforced in the past. And so it was sort of oh, I'm glad you're cutting us a break, but we didn't even know we had to do this in the first place. So it was handled fairly well by very tight communication between PDA and Pennsylvania Farm Bureau to get out there were several webinars, and there was the PDA's Bureau is remaining open to discussions, and it's simply, it's going to be a long process in getting everyone to register their hay rides, because that's really what's really new here, is that people for the first time discovered, for the most part, that they had to do this at all. But I don't know that it's really gone as badly as it could have. Let's put it that way. I think Farm Bureau has been great at making this work a little bit more, at least getting the information out, as has PDA.
And just as a final word, we prepare the Agricultural Law Weekly Review each week, and it summarizes, or it highlights a lot of these developments. And so, if you want to stay up to speed on a regular basis, check out our website or subscribe to that, so that you'll get the weekly review. And it'll, pretty much everything that I've talked about today has been included in that weekly review. And so, moving forward, that's a good way to stay up to date on that. So we're at I have 2 o'clock, so we're at the time for our break. So thanks for your attention, and we will adjourn and reconvene at 2:15 to talk about the 2 Supreme Court cases that are pending. So thank you.